Good morning, honorable members. Welcome everyone who's present in the meeting today. Because we are dealing with some critical matters. Welcome to the DG and with his team DMR.
Recording in progress.
Any apologies?
Good morning, Honorable Chair, Honorable members, and our guests. Chair, we received the following apologies. Honorable Phillips, she's attending another meeting, and the Honorable Minister is attending a cabinet meeting. Those are the only apologies, Chair. Thank you.
Okay. Can we then flag the agenda? Honorable members, we are dealing with in fact, in the main one issue, which is about the legislation, specifically the response of the department on the provincial public hearings. I must say, honorable members, from the onset, we are dealing with questions of clarity. We have not yet arrived at the deliberations where we can express our views or we can challenge the other expressed views. At this stage, when we deal, we'll only deal with questions of getting clarity so that when we deliberate, we deliberate on the basis of an informed approach rather than of a lack of information. So questions of clarity in the main are about trying by all means to get as much information as possible so that we can be able to engage properly amongst ourselves. So I want to appeal, because I know sometimes we get tempted to express or contest the views that are being expressed in relation to what is contained. We will get that opportunity when we deal with the substance of the bill. So I hope we will be able to understand. I don't want someone to say, no, I was blocked from raising a point. I will not, in as much as I wouldn't want to straitjacket anyone, but I would really appeal that we stick to the tasks that we are supposed to do. I have no intentions to express a contrary view to another member to what is proposed on the bill or what is proposed on the submissions that we made. So, because then it's going to drag us back to deliberations when we have not arrived at that point. So I just hope that there will be a common understanding of that. Having said so, with the permission of the committee, can I give the DG the platform with his team?
Thank you, Chairperson.
Yes.
Good morning to you, Honorable Chairperson, and good morning to honorable members and everyone on the platform. Chairperson, I'll also not waste your time. I see she's DDG Ndokozangabe is supposed to be joining the meeting. I think she's struggling to connect, but Mr. Gift Nhlapo, who is the Chief Director in the unit, will be taking us through the presentation in terms of the responses. I will hand over to him, Chair, with your permission. Thank you.
Good morning, Chairperson and honorable members, and thank you, DDG. Thank you, DG. I'm waiting for the document to be flighted. A colleague is assisting to flight the document. On my screen, I don't see it yet.
Have you granted them the hosting right, Ayanda? Oh, okay. Continue.
There it is, Chair. Thank you. Okay. No, thank you, Chair, and thank you, honorable members. The presentation outline, Chair, the purpose, we will outline the purpose and background for the presentation, and we will be dealing with responses by the department on the comments on the portfolio committee's report on public hearings that took place from 26 September 2023 to 29 February 2024. And then the process that the portfolio committee engaged in, from the report indicates that there were 7,011 participants and 1,182 made oral or written submissions to the bill. So this presentation, Chair, will deal with those presentations from the report. But Chair, just for clarity's sake, Chair, we provided a detailed document, the background document that we have extracted this from, contains consolidated inputs from the department, even dealing with the first session that was held in December, so that all the consolidated responses are available. That is the one that forms part B of the report, but the part A is the responses to the report itself. So this presentation is limited to the report, Chair. Thank you. Chair, again, what we did, Chair, in terms of preparing the report, we aligned it with the report itself in terms of the items in the report. So that's why it starts with item 3.1, which talks to the memorandum on the objects of the bill. So on the comments side, Chair, we deal with what the comments required, and some of the comments were detailed, so we just did a high-level summary, extracting the substance of what was there. So on the memorandum on the objects of the bill, Chair, a question arose as to why in the bill we omitted South Africa and wanted to replace it with the Republic. And the recommendation was that the full name of the word of the country, Republic of South Africa, be used. And this comment, Chair, also arose in terms of, other than the oral presentations, it had also arisen from some of the written submissions. So the department, Chair, supports the recommendation, and our proposal would be that we retain the reference to South Africa as it exists in the original bill. This could have been an oversight, Chair, in terms of trying to align the document to try and say Republic instead of just retaining South Africa, because in the definitions, we don't have a definition of Republic. And then, Chair, the next proposal from the Speaker was on the competition with, sorry, ma'am, just the first part. The proposal from the Speaker was the competition with Eskom must be as transparent as possible. A concern around that, Chair, the department noted that, and from the department side, Chair, the bill proposed in sections of 21.3A and 4A and 4B and C are measures aimed at ensuring that third parties in the envisaged competitive market will be transparent, and third parties will have access to the transmission and distribution power systems. Chair, the rationale behind that is that if competitors or parties who participate in the market do not have access to the system, then that will stifle competition and may not enable a proper functioning competition. So those provisions are intended to safeguard third parties to have access to the system, so that the levers for the competition to exist and to be implemented are there, and they are guarded. Next slide. Thanks, Chair. And then on section 3.2, definitions, the report provides for the summary that provides an outlook of the issues raised in terms of consolidated summary of the areas that were contained in the summary of provisions. From the comment side, Chair, there was a comment on the first comment that we dealt with was on the direct supply agreement. It was submitted that the definition excludes generators, traders, and the system operator as customers, and it was recommended or proposed that the proviso must include generators, traders, the central purchasing agency, which is referred to as the CPA, and market operator. Chair, the comment is noted, but it is not supported, Chair, because the envisaged direct supply agreement is envisaged to be entered into between generators or traders and customers. And the disqualifier is that those customers must not become customers who perform activities of the functions of generator, transmitter, distributor, systems of trader, market operator, or the central purchasing agency or CPA. Chair, this is to ensure that these categories cannot become customers amongst themselves, because that, Chair, may impact the security of the system, in the sense that there could be collusion issues, there could be manipulation of prices, manipulation of availability of generated power between themselves. So the direct supply agreements are intended to be restricted to traders or generators and customers, in the context of the exclusion of all these categories of traders of institutions or players in the electricity supply sector. And yes, Chair, that is the rationale for that. It came up for discussions heavily at NEDLEC, and it was agreed that customers should be restricted to the category of only customers, Chair. And then it was also proposed, Chair, that NERSA should not regulate prices of private generators or traders with private generators. And that proposal, Chair, has been supported by the department. And the bill does not contain provisions permitting NERSA to regulate prices of private generators or traders when selling to each other, Chair. There's also a recommendation to amend the definition to include the words of a registrant. That proposal has also been supported, Chair. In the detailed responses, I think they were raised also in the previous session when we received the written comments, and our proposal was also to amend the provision accordingly to have that reflection. And then physical bilateral transaction, the speaker, there was an opinion that the term seemed to be misleading, and seems to be misleading, and then the context of system operator balancing the demand and supply, and then it was asked if there were no ancillary services, because these are intended to stabilize the system. Sorry, Chair, back to that page. Okay. Sorry, Chair, I think what I'm trying to read does not appear in the screen. It's just physical bilateral. It's the presentation seems to be half of that page there. So I'm just trying to get to read it properly, Chair, so that it's read properly in the. Thank you. Yeah. Back, yes. Yes, thank you. Yes, Chair. The concerns that were raised were whether the distributors would not wish to have these ancillary services, and then is in a scenario where the CPA procures electricity to balance demand and supply. A question was asked whether is this bilateral, and the speaker proposed that the use of the term physical seems to be misleading, and therefore proposing that words or terms like national bilateral or public bilateral should be used. Chair, the department has looked at this opinion and noted it, but it is not supported because, Chair, the view of the department is that the term is not misleading. And in terms of the provisions of the bill, 34B, subsection 2, sub A system operator must operate the integrated power system. And when they operate that, they balance demand and supply. And in that process, Chair, they may use or they can use ancillary services. So they are included, ancillary services are included, and the CPA also procures electricity to balance demand and supply in terms of provisions of the bill through physical bilateral transactions that are covered under power purchase agreements. This is where the distinction comes in terms of the first aspect of agreements, that there's a category that has been excluded from being referred to as customers. It's because those categories perform or gets contracted under the physical bilateral transactions through the use of power purchase agreements. And the use of the terminology of physical bilateral transactions, Chair, is a terminology that is industry norms and practices. Thank you. And then, Chair, the next part was dealing with regulated transactions. And the comments was that the speaker understood these transactions to be transactions that have the tariff set by NERSA. And it was submitted that this definition is also misleading because it could include any project that needs to be registered. And I think the speaker also provided a view that unregulated means private and bilateral, and regulated means with a regulated entity like a CPA, and sought clarity on that. The comment is noted, Chair, by the department, but it is not supported. The view of the department is that this is not misleading. The understanding of the speaker is correct, Chair, that the regulated transaction may be transactions that have their tariff set by NERSA, but registered generators who undertake this transaction or transactions that require regulatory approval or oversight will have their transaction overseen as regulated transactions, Chair. And the insertion of that definition of regulated transaction was intended to ensure that where generators who perform functions but are in a dominant market or are dominant, then they need to be somehow oversight over their activities or transaction. So the provision, the key to being regulated is if their transactions fall under the definition of being regulated transaction. And section 1615.4 of the bill, Chair, provides an exception that enables licensees who have direct supply agreements to charge tariffs which have been agreed to in that agreement or charges that are determined by the competitive market. So in instances where section 15.4 comes into play, it creates an exception that can enable participants to have tariffs that are set or agreed to in agreements rather than those that are set by NERSA. And then on the transmission development plan, there was a recommendation that the definition that was in the version that was published in 2022 of the amendment bill must be reinstated. The recommendation, Chair, is supported subject to the definition being aligned with the provisions of the bill, because in terms of the bill, the transmission development plan is referenced to under 2 or 3 sections only. So the definition will be restricted to the reference to them in terms of the bill. In terms of the Central Purchasing Agency, it was asked how will local municipalities collaborate with the CPA and how will this definition affect the relations between municipalities and independent power producers. The questions, Chair, were noted, and the provisions of the bill permit municipalities to enter into transaction agreements with the CPA. And when we look at other instruments that are there in the space, the new generation regulations, when determinations have been made, municipalities can participate in that space. And in terms of Schedule 2, municipalities are also now can generate, because there are no restrictions on Schedule 2. So municipalities can become generators, and if they participate in that space, they may participate in a collaborative manner with the CPA by entering into those transactions through the permissibility of 34B5A and 34B5C, and read together with the other instruments. So municipalities are empowered to also compete with IPPs from that point of view, Chair. Thank you. And then on the day-ahead market, Chair, there was a concern that raised the issue of saying that the definition of the day-ahead market or reference to day-ahead market were deleted from the bill, and there's a section that allows for the market operator to determine the market, which may be a day-ahead market. And I think there was clarity sought as well. The Speaker requested that there should be clarification regarding the meaning and scope of this provision. The comment is noted, Chair, in terms of the provisions of the bill, in terms of 34B, a market operator must develop rules in the market code, and this code or rules must provide for provisions related to the type of markets that will be in place. So these provisions are intended to enable the market operator to define the market without the principal legislation being prescriptive as to the types of market that have to be pursued. This, Chair, has been intended to ensure that the market design that takes place is not constrained by the bill providing the nitty-gritties of how that market should perform, because markets are evolving because of technology and constant changes, and for the bill to catch up, if those were hardwired into the bill, it would become a difficulty to come back and improve or change the markets to match what the changes are. So the rules and the market codes are secondary instruments that will be able to be changed to adapt through the changes that may happen from time to time. So that is the rationale why the bill does not explain a market in the context of hardwiring it into the bill or prescribing it in the bill. Thank you. And then on item 3.3, Chair, it dealt with offenses and penalties. And Chair, there were varying proposals that came from participants. Others were proposing a fine of 1 million rands, and they were saying on the 1 million rands fine, there were proposals brought to the extent that such a penalty should be. The proposals varied from 100 million, 50 million, 20 million to 500,000 or 15,000 rands. And then on the imprisonment term, there were proposals that suggested a 10-year to 15 years, whilst there was support for the proposed 5 years in the bill. And some participants were of the view that the fines should be scrapped and perpetrators imprisoned. And on cable thefts, there were proposals that only those who steal cables, not only those who steal the cables should be arrested, but buyers also should be arrested. Chair, the comments have been noted, and the department is of the view that for the first portion that relates to a person who steals the fines, a fine of 1 million rands and imprisonment of 5-year period will be enough or will serve as an enough deterrent for persons to refrain from committing the offense. However, Chair, I think the department also considered the fact that the people who steal are not only the end of the value chain, so there are people who buy these stolen materials. So the department also proposes that in light of the inputs as well, a new section be inserted to criminalize the receiving or purchasing of the stolen materials, and to provide for penalties for those provisions, at least to a penalty of 5 million or 10-year imprisonment or both for a person who buys those stolen materials. And then on item 3.4, Chair, under the National Nuclear Regulator of South Africa, Chair, there were comments on the electricity pricing. Several comments were raised around electricity pricing. One of the concerns was about the provision that removes the power of NERSA to regulate prices but retains the power to set or approve tariffs. The fear was that prices may be manipulated, and clarity was sought on this. This comment, Chair, has been noted, and it also came through from the comments that were also submitted by the regulator, Chair, previously. And from those submissions, Chair, there's a proposal that this be reinstated so that NERSA will be able to set or approve prices in section 4B2, Chair. And we had engagements with this with the regulator, and they considered, Chair, that it was in error because they initially had proposed that this should be removed. So we were working on their proposals in that regard, but later on then we had engagements, and we support the proposal that this should not be removed from the bill, and where it appears in the entirety of the bill, it should be retained. So that's also, we support that proposal, Chair. And then there were also issues raised regarding the pricing structure and the inconsistencies in the pricing of electricity between customers supplied by Eskom and those supplied by municipalities, especially in terms of the expensiveness of the pricing. Those comments, Chair, are noted. The pricing structures in the pricing of electricity between those supplied by Eskom and municipalities is informed by a scenario where municipalities procure their electricity from Eskom in bulk, and when they resell it to customers, they are permitted in terms of the instruments that regulate the sector to make profit adjustments. So that's the first source of a price differentiation. However, Chair, there's also probably an issue around whether the vastness of the differences in prices, then this also talks to a challenge of resellers, Chair, and that space. So, but the baseline of it is that because they buy it in bulk and they resell and they have to make a profit margin, that's the source of the different prices. And then it was asked again, Chair, if it was not possible for people to choose the supply of their choice. The envisaged proposed competitive market, Chair, is intended to ensure or to enable competition, which is envisaged to ensure that then consumers will have a choice of supply. And then on the issues of the expensiveness of electricity and the issues of the role of resellers, Chair, the department and the regulator have been having engagements around that in terms of relooking at that space to see whether those matters cannot be addressed in a proper manner to ensure that there are measures to address the role of resellers in the electricity supply industry. The next one, Chair, was okay. Sorry. Okay. Then the next portion was around the issue of price fixing. Sorry. Oh, okay. There was an issue raised around on the issue of how price fixing by colluding cartels will be prevented. On how, I think, just to align with what is on screen, Chair. Sorry, yeah. Can you go forward again? No. Yeah. Move one more. One more. Thank you. Yes. Chair, it was also a question was raised around the issues of price fixing. On clarity that how price fixing by colluding cartels will be prevented. And where it was also submitted that NERSA must also be overseen by another structure to ensure that prices are not manipulated. The comments are noted, Chair, and in terms of the bill, Chair, the market rules that are envisaged to be developed are exactly the instruments that is intended to ensure that they monitor and prevent collusion and manipulation and anti-competitive practices. So those instruments that must safeguard against that will find expression in the market rules and market codes. And in addition to that, Chair, the Competition Commission plays a critical role in terms of the investigation of restrictive practices and abuse of dominant positions and collusions. And they also have a concurrent jurisdiction in terms of the issues of price fixing and collusion. So they also have a tribunal to adjudicate such matters. So the price fixing by colluding cartels will also be monitored and prosecuted by the Competition Commission. So the state, Chair, has the levers in terms of the Competition Commission and the provisions that will be made under the market rules to ensure that there are safeguards against price collusions. And then the next part was that speakers feared that the rise of private electricity generation, the ability of NERSA to regulate tariffs in a manner that is affordable for the poor, the working and middle classes, small and medium enterprises. And there was a view that the economy will increasingly be under threat and possibly sacrificed at the altar of profits. Chair, the comment is noted. The implementation of the competitive market, Chair, will have to be carefully monitored to ensure that there's affordable access to electricity. And this, Chair, is intended or must be safeguarded to ensure that there's an alignment with the principle of ensuring that there's accessibility of electricity to the poor households and the people who are not affording. In the balance of balancing security of supply and environmental protection and accessibility, the competitive market will have to be safeguarded or monitored to ensure that there's accessibility. So that is the view of the department, that the threat and possible the threats that have raised fears will need to be carefully monitored and managed during the implementation of the competitive market. It was further submitted, Chair, that NERSA must include consultations when tariffs are being increased and an explanation be provided to communities. Chair, in this aspect, NERSA, when it defines tariffs and prices, it has adopted the multi-year price determination methodology. And when it develops the methodology and reviews this methodology, it undertakes public consultation processes. And this, Chair, it does through the provisions of its founding legislation, which calls for it to undertake those administrative processes. So the comment is noted, but this is exactly what happens, Chair. There are public participation processes that takes place when tariffs and prices are being determined. And then there was a proposal for tariffs for residents and businesses to be separated. And the proposal is noted, Chair. The current prevailing system, Chair, through the ESCOM tariff and charges booklet that gets published, provides for a full breakdown of separate tariffs and charges for all customer bases, including residents, businesses at different consumption levels. So it is there, Chair. Next. I think, Chair, now we'll be dealing with licensing and subcontracting. Under licensing and subcontracting, Chair, there were fears of corruption and collusion, and clarity was sought as to how will the subcontractors be monitored. The comment is noted, Chair. However, the license holders must bear the responsibility for the performance of subcontracted activities, and the regulator, NERSA, is enjoined to hold licenses accountable for the actions of their subcontractors. It was also submitted, Chair, or proposed that subcontracting must be clearly defined and limited, or permits can be legally transferred, including their accountability. And when permit holders cannot perform, their permits or licenses must be withdrawn. And the view of the speakers was that accountability and delivery must be key, and subcontracting should be controlled. No uncontrolled subcontracting should be permitted. The comments are noted, but the proposals, Chair, are not being supported because license holders bear the responsibility for the performance of subcontracted activities, and the relationship between the subcontractor is between the subcontractor and the contractor. In this case, it becomes a licensee, and the licensee's failure to perform according to their license obligations, even if they would have subcontracted that, will result in the regulator holding the licensee responsible and accountable for the failure. So the system of the subcontractors in this context should be well managed under the license or the subcontracting agreement by the licensee, but the regulator always has oversight of the performance of the functions and holds the licensee accountable. It was further submitted, Chair, that when the holder has caused problems and transfers the right to someone else, they must still be held accountable. This comment, Chair, is noted. However, there's no subcontractor who can transfer their authorization or their subcontracted rights to somebody else, as probably alluded here, because the transfer of a license is regulated by NERSA, the regulator who performs due diligence before a transfer of a license is approved. And the regulator always has oversight in terms of Section 21 over the licensee. And the licensees are not permitted to cede or transfer such powers without the concurrence or without the regulator agreeing to that transfer or cession. And then, Chair, there was a reference made to the Section 10.3 and 11 around the participants, noting that the bill is silent on how the regulator must deal with objections to advertised licenses, intention to apply. And the participants also urged that the issues of protection of commercially sensitive information as proposed in the bill must be relooked at. The speaker cited the issues of different electricity prices between Eskom and the municipalities and the prices that are illegally added by the spaza shops on electricity prices. Chair, the comments have been noted, and in terms of the provisions of section 10 and 3 and 11 on the dealing with objections that are raised on an application, that process is an administrative matter, Chair, which the regulator deals with in terms of its internal processes. And the department is of the view that does not need to prescribe for this to be in the bill, because it's an internal administrative process for which their is guided by the National Energy Regulator Act. And the proposals for this 10.3 is a discretionary tool where an applicant is of the view that their information is of a commercially sensitive nature and they can request the regulator to protect such information. So it's a request that the regulator must still apply its minds and decide whether it accedes to that or not. And as I mentioned, Chair, the Energy Regulator, National Energy Regulator Act enjoins the regulator to undertake its activities or to perform its administrative functions in a manner that is accountable, that is compliant with the prescripts that entrench fair procedure and fair processes where affected persons have the opportunity to submit their views and present relevant facts in terms of whether they object to those activities or not. And the protection of commercially sensitive information will be done in accordance with those prescripts. And then, Chair, on the vesting contracts, Chair, there was a comment with regards to the provisions that in the bill addresses vesting contracts, which are found under Section 34B. And the Speaker wanted an insight into the implications of the conclusion of vesting contracts. The views of the Speaker, Chair, were expressed, and the proposal made was that there must be words added to the provision to provide for the regulator to approve the prices, because this was going to ensure that it introduces a safeguard in terms of the concerns that were raised by the Speaker, Chair. The comment, Chair, is noted, and the proposal is supported, and the proposal is that that section will be amended accordingly in terms of insertion of the proposed wording. And then, Chair, the vesting contracts were envisaged to enable Eskom generators and distribution licenses to have secured power purchase agreements as well, which are similar to the IPP regime, because with the unbundling process that is taking place, Eskom generation will remain a category of generators who also have to compete or will have to enter into or may enter into the market with the IPPs through the CPA. So Eskom generators and distribution licenses, and under distribution licenses, there are municipalities as well, do not have a system that protects them the way the IPPs are structured in terms of those power purchase agreements that are entered into by IPPs. So from an inside perspective, vesting contracts are also intended to ensure that the Eskom generators and distribution licenses also have a vehicle to enter into those agreements as well. On the CPA or Central Purchasing Agency, the proposal was that the bill refers to a CPA, and in fact, there's only one CPA. So the proposal was the use of the word there instead of a. That proposal is noted and supported, Chair, and The next part, Chair, was on the central transmission system operator. Oh, sorry, Chair, I think I was ahead of myself. I think that first comment has been noted on that use. And then the other view was that the functions of the TSO are less clearly delineated in the bill as opposed to the 2022 bill. And the proposal was that the functions of transmission expansion plan, forecasting and scheduled dispatch, the proposal is that this should be included. The comments were noted, Chair, and we support that proposal to include those functions of developing a transmission plan, performing forecasting and dispatching schedule under the TSO under Section 35, Chair. Additionally, Chair, there was a comment that whilst the TSO was welcomed, there were concerns that of corruption in that the TSO will be 100% state-owned and a subsidiary of ESCOM. The department notes the concern, Chair, but we cannot express a view on the suspicion of corruption except to reinstate, Chair, that acts of corruption should be dealt with through appropriate law enforcement agencies where they are suspected and picked up, Chair. The next one, Chair, is on the National Transmission Company of South Africa. Here, Chair, it was a recommendation of a name change from National Transmission Company of South Africa to a National Generation, Transmission and Distribution Company of South Africa. The view was that all three functions are envisaged in the draft bill. This comment, Chair, is noted, but it is not supported because the provisions of the bill, Chair, introduce measures for the markets to give effect to the energy policy and ESCOM roadmap. So the roadmap provides the restructuring of ESCOM into its holdings with three subsidiaries, which is generation, transmission, and distribution. And these entities perform different roles in terms of the roadmap, and transmission is a separate entity from generation and distribution. So these provisions that are in the bill, Chair, through the NTCSA have already been established, and they give recognition to Section 35C by deeming the National Transmission Company of South Africa to be the transmission system operator and to perform these functions of the TSO. So there is a clear delineation of the different roles of transmission and generation. So it is not a correct view that the transmission company should be renamed and cover the entire value chain of the unbundled entities. And then there was a proposal that the minister may make determinations under clause 27. I think this talks to the provision, Chair, where the minister has a discretion. So the proposal was that it should be changed to a must under, I think this speaks to Section 34 determination that the minister, the provision says the minister may make determinations, but the proposal is that the provision must say the minister must make determinations. And that, Chair, would be making it obligatory for the minister to make determinations. And that view, Chair, is not supported because the minister's discretion or obligations towards ensuring security of supply emanates from the minister evaluating a variety of prevailing conditions and then deciding whether a determination should be made. And when the determination is made, it's informed by various prevailing conditions. So to make it obligatory for the minister to make determinations, then we'll lose the context of the minister having to apply the mind in terms of a discretion of whether it requires to make a determination under or not under certain conditions. So that is the basis on which the view is not supported, Chair. And then, Chair, the next part was on item 3.6 and embedded generation. Chair, the the speakers, the highlight was that embedded generators no longer need to apply for licenses, but only need to register, and they can also sell surplus energy back to Eskom. The speaker did not agree with this and argued that this can cause non-compliance with the grid codes, and entities or municipalities that might have power purchase agreements with IPPs can be exposed also to non-grid compliant electricity, and proposed that extra measures be put in place. Chair, the comments were noted, but they were not supported because in terms of Schedule 2, the threshold has been removed for embedded generation. However, this relates only to licensing provisions, but not to the application of other provisions of the Act. So what that means, Chair, is that even in the bill, there's also provisions under Section 9 that are being proposed to deal with the integrity of the grid, that ensures that embedded generators who want to come into the grid still requires to comply with the technical, financial, technical, and other requirements that ensures that the grid integrity is retained. So Schedule 2 does not give embedded generators the automatic right to connect to the grid or to sell their energy without them having to comply with applicable legal and technical prescripts, Chair. And then there was a view, okay, this comment related to areas that were not part of the bill. The speaker submitted that it does not see much support for municipalities that envisage entering into long-term power purchase agreements with IPPs because of the applicable legislation that guide and also limit the processes. Chair, this comment has been noted, but the department does not have a view so much on this aspect, Chair. I think there was this item 3.7, Chair, which related to local government perspectives. So, Chair, there were inputs made around a proposal to insert various definitions, and these definitions were provided as well in the submissions. And Chair, these were all noted, but they are not being supported for inclusion in the bill, Chair, because the bill does not contain provisions that speaks to these aspects, Chair. And all these proposed definitions relates to embedded generation related activities. And all those activities, Chair, are regulated under, are technically regulated under grid codes and technical documents. The proposed definitions and under these sections, Chair, are proposed that they will be best suited in those secondary instruments like grid codes and technical documents that gets issued from time to time. And then on the power market participants, Chair, there was a view that sought clarity regarding the definition of power market participants in the bill, and it was asked, how is it that local government fits in this definition, as local government is deemed being a participant in the power market? Alternatively, the word participants must be defined and include local government. The view was that local government are participants in a power market. Chair, this comment was noted, but not supported, Chair. We struggled, Chair, to grasp our mind around it properly, because the submissions made in it seem to be explaining the same thing as if it means the same thing. But, Chair, from a clarity perspective, is that the definition of power market participants is not restricted to, is not exclusive of any specific person. It is couched in an inclusive manner to ensure that anyone who meets the qualifying criteria and choose to participate in the market then becomes a participant. So it is a neutral definition, and municipalities or institutions that either fall under local government who are in the generation of electricity, even if they are state-owned entities, could still become market participants because they'll be generating and seeking to compete with their generated power into the market. So that is the clarity that we would seek to proffer, Chair. And then then issue of this one's item 4, Chair, issues outside the ambit of the bill. There were various issues raised on which were outside the ambit of the bill, around meter boxes consuming too much electricity, as well as damage that is done and vandalism of infrastructure, and the consequences of these lasting for long periods. And there were also issues that were raised around ESCOM penalizing residents and asking them to pay certain amounts for restoration. And there were issues that farm dwellers remain unelectrified as the farm owners hinder the electrification process. These comments, Chair, were noted, and since they do not relate to the provisions of the bill, the department did not express a view on this matter. And yeah, Chair, I think that is the end of the clarity that is provided around the report, Chair. Thank you, Chair.
Yeah, that's the update from the department in terms of the responses. I hand back to you. Thank you.
DG?
Yes, Chair. Yes, Chair. I just indicated that we are done in terms of the presentation that we had prepared for today, and I'm handing back to the Chair. Thank you.
Okay, we will try and handle it in a manner that helps us going forward. Honorable members, there is the presentation. Any questions of clarity from honorable members? Good morning, Advocate Maynard Jenkins.
Good morning, Chairperson and members, and happy Valentine's.
Oh, a romantic lawyer, happy Valentine. Okay, I guess there is no, anyway, we dealt with this issue. It's only the fact that the department had to come and respond on the proposals or the takes. I see the hand of Honorable Ceza. Is there any other question of clarity that honorable members wants to have? Going 1, going 2, going 3. Okay. Let me give to Honorable Ceza.
Thank you very much, and good morning to you, and good morning to the department and the presenters and general colleagues. Chair, there is a glaring cut across concern about the issue of that has raised corruption within the TSO and how it's going to be curtailed. And I've heard this at a municipal level, provincial level, when we took on municipalities at Kokta. And there's a person that is held to account in terms of the legislation, and that person is the municipal manager. And in terms of what this submission says this concern is saying. It questions the corruption, the curtailment of corruption in the event that it happens. And I'm saying that you see it across all departments because of probably the procurement system and the price fixing that comes with the tender system. My question of clarity is who is going to be held liable now? Perhaps I get an understanding, given the fact that, of course, I'm new in the committee. Second, Chair, is that, and the last is the existence of the two providers of electricity at a municipal space. The municipalities, there's another concern that in the public hearings that we heard over and over again about the existence of ESCOM and the municipalities, and the municipalities having to buy a bulk of electricity from ESCOM and sell them to consumers. But in the process, they do a markup that will actually speak to the surplus that they will be making. But does that consider, how does that consider the tariff lifestyle within a month? Say that you buy electricity at block 1 of tariffs, and then during the month, say you buy again and you find that it's at block 2. How is it that it affects the consumer and interoperability of electricity? I just want to get an understanding, so that I brought in my understanding as I read on daily basis on these matters and difficult concepts, as it were. Thank you very much.
Okay. Because it's a February 14, let me use my heart. Next time you will be coming at the wrong time. Honorable Mailem, I can see now your hand is up. Honorable Mailem.
Thank you, Chairperson. I'm feeling the love today. Chairperson, my question relates to Section 34 of the Act, and the clarity I seek is this. In the departmental response, they say that the IRP will be developed in terms of the processes of the IEP. Now, the IEP is, the processes of the IEP are defined in Section 6 of the National Energy Act. My question is this: the IRP is a distinct subset of the IEP, and as such has its own processes. And so the question is, why are we taking away a process which this piece of legislation specifically identifies as being needed and required? And why are we saying that it is no longer? I'm unclear as to why that section was deleted from the 2022 amendment bill and not kept in the 2023 amendment bill. So I'd really like some clarity in that regard. Thank you, Chair.
Okay, I see that it's only those two hands. The distinguished DG and your team, there are the two questions. There are three, in fact, but from two.
Okay, thank you. Yes, thank you, Honorable Chair. Let me deal with the first two questions, and then I'll allow the colleagues to deal with the question around the deletion related to the IRP. I guess, Chair, in terms of the issue of corruption, I think the colleague as he presented from, I think that the issue that the member raised has to do with, I think the member honorable member was referring to what happens at municipal level. Obviously, in terms of the bill and the establishment of the transmission system operator, the TSO will remain part of ESCOM, and all issues related, obviously, to malfeasance or corruption will have to be dealt with within that space in the ESCOM, obviously, domain. And as the colleague had indicated, obviously, in consultation or with obviously the necessary law enforcement agencies. I think from where the issue was raised, that's how we can respond to that question. Chair, then the next question, which has to do with the tariffs, the issue of Block 1 and Block 2. What happens with the tariffs is that the regulator, there is a lot of municipalities, including ESCOM, they have in place what they call inclined block tariff. And this is the case even in the water space, whereby for the first, I think, about 500 kilowatt hours, you pay a certain rate. If you use beyond that rate, you start paying obviously more for additional units. So hence you'll find a situation where if people have exceeded the first tranche of units in this inclined block tariff, they will pay a different rate for the next tariff. For example, you'll find that the first unit you pay R1 up to 500 kilowatt hours. Between 500 kilowatt hours and 1,000 kilowatt hours, you find that you pay R120. Anything beyond that, you may find that you pay R150. So, and that is meant obviously to manage use in the month, but it's also meant to protect the poor, because what you find with that tariff setup is that majority of households will use probably up to 500 kilowatt. Those who can afford tend to use more electricity, and that's why you have this inclined block tariff. So the changes that people would normally see in the tariff is related to that. The other point that I must raise with regard to tariffs is that in our response, we responded that you get areas supplied by ESCOM, and then you get areas supplied by municipalities. And in those two tariffs are generally approved by the regulator. Where the challenge is, it's generally where, and especially in a lot of municipalities, where municipalities allow the so-called resellers to be the ones that are reselling electricity to consumers. You find that most of these resellers, because they buy from the municipality and they resell, for example, in most of the housing estates or complexes, you find that people are buying from the likes of Protimetering, who actually have an agreement with the municipality. And obviously, in addition to what they buy at the rate from the municipality, they tend to put an additional markup on that. What we've tried to do to empower the regulator, there is a section under Schedule 2, where we had put a provision that says that where the reseller is selling at the same rate as the municipality, then that is fine. There is no problem, because then the consumers in the area will get the same tariff. And then we said where the reseller is selling at the rate above that of the municipality, then the reseller needs to be approved by the regulator. So the tariff that the reseller wants to use needs to be approved by the regulator. So basically, that's where generally you find that there is still a gap in terms of regulating the tariff check. Let me hand over to DDG Ngwabe and the team to respond to this question around the deletion of the section on the IRP.
Okay. Thank you, DG, and thank you, honorable members, for the question. Chair, the promulgation of the provision that brings into effect the IEP was also a critical contributor to the removal of the proposed processes that was in the 2022 provision, because, Chair, the IEP prescribes a process for the review of the Energy Act. Prescribed the timelines as well for the review of the IEP, and it requires that it needs to be reviewed annually. And, Chair, the IRP is a subsector. Honorable member has mentioned it, that it's a distinct subsect of the IEP. And as the department will be developing this, it's not the only distinct one. There are other ones that fall in other areas of the energy space that needs to be developed. So when the department reviews this in that annual basis, it has to engage it, to deal with it in an integrated manner. Okay. So another legislation would not be ideal to prescribe a different process to the ones that is intended to result in an integrated energy policy or plan for the country. So the view of the department has been that in the process of developing the integrated energy plan and the reviewing of it as prescribed by legislation, then the IRP would also undergo such processes, because then we may be introducing different processes for the development of a document that is a subsector of another process that is also prescribed by legislation. Chair, that was one of the reasons why it would have been removed or taken away in terms of that specific process. No, thank you, Chair. I think that would be sufficient.
Chair, those are the responses. I hand back to you.
Okay, thank you, DG, and Mr. Tapo. I think let's then say that, honorable members, we are at liberty. At least we have dealt with this exercise before. It's not going to be something that is new. I think we have to carry what is our views. I can see, Mr. Nhlapo, that that issue, in my view, we'll have to test it as we deal with the bill. I don't want to deal with what are my suspicions of the shortcomings. With regards to the two issues, I think we have got the answer. For me, I would have said I agree with the TSO and ESCOM, but we'll have to look at when we deal with legislation, proper accountability measures, whether they shift because of the legislation. I think that's one issue that we just have to deal with them, including cooperation. One thing, DG, I wanted to leave, I think it's related to the answer you gave to the last one. I just want to leave that I'm of the view that when we deal with the legislation, most definitely we will need to unpack more on the different aspects, especially on the role of local government, as well as the role of the entity, the private entities and the TSO under ESCOM. I think it's going to be very critical to make sure that we are quite clear of what becomes substantially a role of each different entities. Honorable members, I think we have come to the conclusion of the presentation and the clarity questions. I think our advantage is the fact that we are not dealing with the issue from scratch. Most of the submissions that were made are submissions that are related to the written submissions. On that note, where are we now, Ayanda and Ari? In the motion of desirability, am I correct?
That is correct, Chair.
Yes.
Okay. Guide me.
Oh,
Are we? Yes.
yeah, no, it's fine, Chair. No, the consideration and adoption of the MOD, it's part of the formal processes, Chair, in processing the legislation. So Rule 286 of the NA rules, subsection 4 and subsection 6 deals with the MOD, Chair, where the committee must adopt or reject the MOD. The adoption of the MOD relates to whether the principles of the bill and the need for the bill are accepted by the committee, Chair. So that's it in a nutshell, Chair. Maybe Frank or Buyoseka can maybe expand if need be, Chair.
Or you take us through the proposed format.
That's fine, Chair.
On the, because I was going to say, you can take us through it, and then members, if they feel that there is something more that is needed to be factored in. Otherwise, in simple terms, we would just say, yes, we agree there is a need, or no, we don't agree that it is a desirable bill. But I would think that what you have put in as a summary is what the committee has to take into consideration in principle of us being in agreement on the motion of desirability.
That's fine, Chair. So on the Electricity Regulation Amendment Bill, the motion of desirability reads as follows. That in the opinion of the Portfolio Committee on Mineral Resources and Energy, legislation is desirable to amend the Regulation Act 2006 so as to delete, amend, and insert certain definitions, to provide for the application of the Act, to provide for the National Energy Regulator to consider applications for licenses and the issue of licenses, to provide for revocation and deregistration of licenses, to provide for additional electricity, new generation capacity, and electricity infrastructure, to provide for the establishment, duties, powers, and functions of the transmission system operator, and transitional measures, to provide for an open market platform that allows for competitive electricity trading, to assign the duties, powers, and functions of the transmission system operator to the National Transmission Company South Africa, to provide for delegation and assignment, and to provide for offences and penalties, and to provide for matters connected therewith. That's the MOD, Chair, for the era.
Advocate Jenkins, before we come into honorable members, Honorable Jenkins or anybody else from your legal team?
Chair, no, thank you. I'm here to deal with this bill, and my colleague Buyiseka Mtati will deal with the next bill. So I'll take this one, Chair. There's nothing, there's everything correct about this, Chair. The rules require that once the committee has familiarized itself with the objects and the purpose of the legislation, it must decide whether it wants to now continue discussing this legislation and report to the House after that. So the procedural steps indicated by my colleague Rico is 100% correct, Chair, and what I'm reading, it's 100% fine. So as you said, actually, Chair, the committee needs to support or not support this motion of desirability to give effect to that rule. Thank you, Chair.
Thank you very much. So in essence, let's all agree it does not deal with the actual substantive matters, but it in principle agrees that those are the areas that the committee agrees that they should be attended to by agreement or disagreement as we move forward. And I think if that is the case, can I get then someone who supports or moves the issue, or if there is agreement that we approve the motion of desirability of the bill?
No, I don't approve.
Honorable Gaza?
It's a no for me, Chair.
Okay, there is a no from Honorable Gaza. Is there anyone who supports the no? Going 1, going 2, going 3, there is no support.
Sorry, Chair, the mic
Yes.
of Honorable Mahlaule is on. I think he's trying to say something.
Yes, I'm coming to the issue because there is a motion. There seems to be no support. Is there support for the motion of desirability?
Chair.
Or let me get Honorable Mahlaule whether you wanted to speak on the first one or on the second one. Honorable Mahlaule?
No, Chair. Greetings to you and greetings to everybody on the platform. Ability of the bill.
Did I get Honorable Mahlaule? Is it on my side?
Chair.
It seems to be struggling with network, or is it me?
No, it's not you only,
It's
Chair.
not you only, Chair.
Chairperson, can you hear me?
Yeah, now you're okay.
I said I want to propose that the committee supports the motion of desirability on the bill. Did you get that?
Yes,
Chair?
although it does. Yes, I think I got it, although there was a bit of a stumble, but I got the general trust, including the support for the desirability of the bill. Any seconder?
Chair, I second the question of desirability on the bill as proposed by Honorable Mahlaule.
Because there is a seconder, it then means that we can proceed except if there is a different approach or advice. Advocate Jenkins, I just see your face. Okay, I get you are correct. Can we, what is the next one? It will be on the NNR?
The NNR, yes, Chair.
Yes.
The motion of desirability of the National Nuclear Regulator Amendment Bill, B25/2023, reads as follows. That in the opinion of the Portfolio Committee on Mineral Resources and Energy, legislation is desirable to amend the National Nuclear Regulator Act of 1999 so as to substitute certain definitions and insert new definitions, to authorize the regulator to perform additional regulatory functions, to provide for conditions applicable to the transfer of responsibility for authorized activities, to provide for additional powers of inspectors, to provide for financial provision for costs associated with safe rehabilitation or decommissioning of nuclear facilities, to provide for administrative fines, to provide for the establishment of the National Dose Register, to provide for a centralized database of radiation workers, and to provide for matters connected therewith. That's it, Chair.
Madam Tati.
Morning, Chair, and morning, honorable members. I have looked at the motion of desirability as flighted on the screen, and Chair, I agree. I support what the Secretariat has indicated. I've gone through that motion of desirability, and that what is left for the committee now is to look in terms of the rules, NA rules, whether the committee accepts the bill or reject the bill. Thank you, Chair.
Okay, thank you very much. At least we are legally within the framework of the process and the procedures and word content. Any person who move for the motion of desirability, support the motion of desirability. Honorable, I say Honorable Mahlaule.
Chairperson.
Yes.
Yes. The NNR.
Mr. Mahlaule, you're breaking up again, sir.
Chairperson, can you hear me?
You are excellent now.
My apologies, I don't know what's going on, but I want to move for the adoption of the desirability of the motion on the NNR bill.
Okay, thank you very much, Honorable Mahlaule. Any seconder?
Chairperson, I do second.
Okay. Honorable Volmarans, I think Honorable Makeke wanted to add the support, the desirability, motion of desirability. Any objection on the motion of desirability on the NNR bill? Going one, going two, going three. Then it means the motion of desirability is agreed to. Thank you very much, honorable members. Is there any other matter?
No, Chair. Just to indicate, Chair, that we next week we'll start with the deliberations on both the ERA and the NNR bill, Chair. Next week, Tuesday.
Okay. On that note, honorable members, the meeting stands adjourned. Thank you very much until further notice about next week. Thank you very much. The meeting is adjourned.
Thank you. Thank you, Chair.